Thank you, Mr. President. I am back now for the 28th time in my series of speeches on the special interest scheme to capture the United States Supreme Court. What I'd like to do today is to talk a little bit about the Judicial Conference and what the Judicial Conference has been doing to help clean up the mess at the Supreme Court. I suppose I should start with what is the Judicial Conference? The Judicial Conference is a body created by Congress around 100 years ago as the chief governing and policy-making body of the federal judiciary. It basically supervises the administrative side, not the adjudicative side, the administrative side of the judicial branch of government. It is chaired by the Chief Justice, and its membership is composed of the chief judges of each circuit and of the Court of International Trade. So it's a very distinguished group of very senior appellate judges and a district judge from each circuit, typically a chief judge or a senior judge. Again, it's a pretty distinguished group. The conference is responsible for, among other things, enforcing ethics rules and overseeing financial disclosures and setting other policies across the federal judiciary, which it mostly does through committees. It has committees on issues ranging from financial disclosure to things like courtroom security. The Judicial Conference has a very important role enforcing judicial ethics rules. Ethics rules are within its ambit of responsibility. Now, bearing in mind the recent ProPublica story concluding that the Judicial Conference has, to quote the story, often protected, not policed, the judiciary, I wanted to share my experience as I've conducted this investigation and how we've been able to work with the Judicial Conference. First, let me say as a general matter that the Judicial Conference is very reticent. Getting even basic information like which judge serves on which committee is an uphill struggle. Last year, Business Insider, the publication, sought the list of members of the Committee on Financial Disclosure, and the conference initially denied the request. I'm not going to tell you, saying that the names of the members of the committee are not public, which is kind of a strange position to take when they're paid by taxpayers to do that work, and all you're asking is who they are. But thankfully, later, the conference reversed course. I have requested that the Judicial Conference disclose information like who sits on its committees and what rules they operate by, but so far I have not yet received a formal response to that, and I very much hope that the members of the Judicial Conference will make this information public. Transparency is not a bad thing in this area. Anyway, through all of its established reticence, when I have brought issues to the attention of the Judicial Conference through correspondence or through remarks that I deliver at the conference's twice annual meetings in Washington, which I'm invited to in my capacity as the chairman of the Senate Judiciary Courts Subcommittee, the conference has generally produced positive results. My requests have covered 4 areas, and I'll give you a quick overview of where those matters stand. First, I'll talk about the disclosure rules for amicus curiae briefs, friend of the court briefs. Dark money front groups send flotillas of amicus briefs to the Supreme Court. The justices and their clerks read these briefs. They often cite them in their official decisions, but it's basically judicial lobbying. And the problem is that this flotilla of amicus briefs doesn't have to disclose the true source of the funding behind the briefs. So neither the justices, nor the other parties, nor the public gets to know who's really paying for these arguments to be presented to the Supreme Court. Nor do we know the interconnections among the front groups. To what extent are they a single web of front groups masquerading as a great number of individual entities? We know for sure one thing: there was a brief filed under the fictitious name of another organization. It wasn't even a real entity that filed the brief. It was the, quote, fictitious name under Virginia law of a completely different group. And that was done without disclosing the name of the actual group to the court. That means it's left to offices like mine to track these groups and then explain to the court, which we do in our amicus briefs, how all of this flotilla of briefs is coordinated. Very often, we see common dark money donors. Very often, we see the fingerprints of the right-wing billionaire's court fixer, Leonard Leo. Time and again, dark money groups pay huge sums to support right-wing justices' confirmation onto the court, and then turn around and file amicus curiae briefs to signal to those justices who they helped get on the court how they should roll. So since 2019, I've asked the Supreme Court to strengthen its amicus disclosure rule. After much badgering, the court, to its credit, sent this matter to the Judicial Conference for consideration, where at the Judicial Conference it was in turn referred to an advisory committee. Although that advisory committee hasn't yet formally proposed a rule change, things look promising. These judges who make up the Judicial Conference well recognize the importance of, as one judge said, knowing what she called the real power behind the throne in these flotillas of amicus briefs. It is also encouraging to hear judges on the committee recognize that there is a broad agreement, which they said, on the need for better disclosure. As always, the devil will be in the details, but thus far, the Judicial Conference is on the case. It has announced that it is examining the matter. Another issue that I have raised with the Judicial Conference is what I call the Scalia trick: misuse of the personal hospitality exception in the financial disclosure rules. Justice Scalia got this trick named for him by taking dozens of high-end hunting trips for free, and he used this rule to avoid disclosing them. He pretended that a personal invitation from a resort owner whom he had perhaps never met made it, quote, personal hospitality protected by the rule. Senator Graham and I first sent a bipartisan letter to the Supreme Court about abuse of the personal hospitality exception back in 2021, and I'd ask unanimous consent to have that letter appended at the end of my remarks. After that, I sent several more letters asking the court to address the Scalia trick, and I'd ask those 3 letters to also be appended at the end of my remarks.
Without objection.
The good news is that in March of last year, the Administrative Office of the Courts wrote me to say that the Committee on Financial Disclosure would clarify its regulations on personal hospitality. I'll quote that word again, clarify, because it matters later. And sure enough, when the clarification came out, the Judicial Conference slammed the door hard on the Scalia trick. So no more secret flights to and from hunting trips across the country on someone else's dime. No more secret personal hospitality paid for by a third party. And no more secret personal hospitality, so-called, at properties owned by a corporation. I count these clarifications as a win. So I'll put that into the win column. There is a related question still pending from that. Justices Thomas and Alito claimed last year this same exception, the personal hospitality exception, let them accept their secret gifts of jet and yacht travel from right-wing billionaires without reporting it. In his most recent financial disclosure report, Justice Thomas claimed that he could keep those past gifts secret because what he called the committee's new rules, his description, didn't go into effect until March 2023. And there I disagree. The disclosure law was always clear. It was the Judicial Conference's guidance that hadn't headed off the Scalia trick, likely because nobody imagined that any judge would be so bold as to have intermediaries ask resort owners to send them invitations for free travel and then call that personal hospitality. Anyway, the judiciary's letter to me said that the change was a clarification. And that word choice matters a lot here, because if it was in fact a clarification, then Justice Thomas and all the rest of the Supreme Court must amend their past filings to comport with the law, because it had always been that way. And they'd have to disclose all the freebies kept secret in previous years. So pending at the Judicial Conference is my request that the conference clarify whether the revised guidance constituted a clarification or a rule change. I do not have a response to that yet, but the end of the Scalia trick was a considerable win. I've also contacted the conference about how omissions in Justice Thomas's financial disclosure report were handled by the conference back in 2011. And I would ask unanimous consent that that correspondence be also appended at the conclusion of these remarks.
Without objection.
Thank you. Back then, Justice Thomas failed to disclose $700,000 that the far-right Heritage Foundation had paid his wife over several years. Justice Thomas's undisclosed jet and yacht travel, paid for by the right-wing billionaire Harlan Crow, also became public for the first time. So members of Congress and a watchdog group sent the 2011 omissions to the Judicial Conference's Committee on Financial Disclosure for review. Under the law, the conference is required to refer the matter to the Attorney General for further investigation if there is reasonable cause to believe that the violations may have been willful. Last year, my court subcommittee heard testimony from a judge who was then on the Judicial Conference who raised serious concerns about the conference's reasonable cause inquiry. There was actually no indication that a reasonable cause inquiry was made. So in August, I wrote to the administrative office to find out more about what really happened. The administrative office acknowledged my request, but I have not yet received a response to my questions. The Judicial Conference is also considering Justice Thomas's more recent financial disclosure omissions. Congressman Hank Johnson, who is my coordinate as the top Democrat on the court subcommittee on the House side, and I wrote to the Judicial Conference several times, along with other members of Congress, asking for review of these ethics violations and a determination whether referral to the Attorney General is required for this second round of yacht and jet travel from Republican billionaire Harlan Crow, for the real estate sale from Thomas to Crow, and for various gifts from other ultra-wealthy individuals, including Paul Novelli and David Sokol. And I would ask unanimous consent that those letters be appended at the conclusion of these remarks. There are three of them.
Without objection.
As in 2011, the current matter has been sent to the Committee on Financial Disclosure. We don't know exactly how the committee's review is going, but the Judicial Conference's report on its September meeting, its most recent meeting, included this interesting note on the committee's activities. The note said the committee was, and I'll quote here, updated on the status of the ongoing review of public written allegations of errors or omissions in a filer's financial disclosure reports that were referred to it since the conference's last session. So it seems like that is this matter, and it seems like that investigation is an ongoing review. The final issue I've raised with the Judicial Conference is my complaint against Justice Alito for what I thought was a pretty blatant ethics violation last summer. I addressed this complaint to Chief Justice Roberts in his capacity both as Chief Justice and as Chair of the Judicial Conference. And I'd ask unanimous consent to have that letter appended also at the conclusion of these remarks.
Without objection.
The Supreme Court, unlike every other federal court, has no procedure for receiving or investigating ethics complaints. So that's why I sent it to him wearing both of those hats. The first thing I asked Chief Justice to do was to change that. There should be a place where with a complaint like that, I could go and file it and somebody would pay attention. I also asked that either the conference or the court conduct its own investigation into Justice Alito's comments in the Wall Street Journal's editorial page made in an interview with David Rivkin, where Justice Alito offered his legal opinion that, and I'm quoting him here, no provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. Well, seems to me that's a slam dunk ethics violation for a couple of reasons. First, Justice Alito was opining on the constitutionality of my Supreme Court ethics bill, which the Senate Judicial Committee had recently advanced, and the legitimacy of related oversight requests from the Senate Judiciary and Finance Committees. We have heard time and time again from Supreme Court nominees, including Justice Alito himself, that it is improper and a disservice to the judicial process. Those are Justice Alito's words in his nomination hearing, for them to express opinions on a matter that might come before the court. Well, boom, this was a matter that might come before the court. Indeed, it was actually likely to come before the court. And there he was opining at will in the pages of the Wall Street Journal editorial page. But it gets worse. He made his comments in the context of a specific ongoing legal dispute, a dispute involving the court fixer, Leonard Leo, who had arranged for an undisclosed free jet trip and fishing excursion for Justice Alito and himself. When the Senate Judiciary Committee requested information about the gifts Leo arranged, we got a letter back from his lawyer, David Rivkin, the same person who conducted the interview that recruited the comment from Justice Alito. Justice Alito's comments in the Wall Street Journal echoed the exact argument that Rivkin had made when he refused to give us any information, i.e. that Congress has no authority to legislate on or oversee Supreme Court ethics, which is a weird position to take when you consider that the Judicial Conference, which oversees Supreme Court ethics, was created by act of Congress. Anyway, the cherry on top of this whole mess, which I flagged also for Chief Justice Roberts in a follow-up letter, which I'd ask unanimous consent to append at the conclusion of these remarks,
Without objection.
came a month later when another billionaire, also alleged to have provided Justice Thomas with undisclosed gifts, cited Justice Alito's comments as support for his argument that his billionaire didn't have to answer our questions about those gifts. I sent that letter to Chief Justice Roberts as an addendum to my complaint, and I have not yet heard back. But it really does seem wrong that a justice of the Supreme Court would offer an opinion on a matter that might come before the court that actually relates to a specific ongoing legal dispute in which the lawyer for a party in that ongoing legal dispute is doing the interviewing, and that the person that that lawyer represents is a friend and associate of the justice himself, and that the result of that activity is that gifts to that very justice are kept from public view, orchestrated by the client. It's a mess. The last thing that we have is a letter that Senator Wyden and I just sent to the acting director of the Judicial Conference related to the recreational vehicle loan that Justice Thomas received. It appears from the Finance Committee's investigation that the principal on the loan was never repaid, not a dollar of it, that for a period interest on the loan was repaid, but then interest stopped being repaid. When you stop paying both principal and interest, that amounts to an act of forgiveness of the loan, and yet the forgiveness of that loan was never declared on his judicial ethics filings, suggesting that it might not have been disclosed even in his tax filings, which could lead to a whole second set of legal concerns. So I ask unanimous consent that the letter and the attached report be also appended at the conclusion of my remarks.
Without objection.
So it's not fair to expect the Judicial Conference to have done anything about that because it just was sent to them. But with respect to the other things, I'd sum it up this way. The score at the Judicial Conference so far is one clear win on getting rid of the Scalia trick, major progress on disclosing who's really behind front group amici, ongoing review of the billionaire gifts program at the court as it relates to Justice Thomas in particular, and so far no response on the Alito Wall Street Journal mischief. So it's, like I said, it's a very reticent place, and they move very slowly and with a lot of process, so I'm just going to continue to press along, bringing information before the Judicial Conference so that they and the public can get clear answers on these issues. Certainly the American people deserve transparency when it comes to fairness and gifts from interested billionaires to justices of the Supreme Court. And with that, to be continued, I yield the floor.